Hobby Lobby won at the Supreme Court. The Supreme Court saying corporations, some can hold religious objections that allow them to opt out of the new health care law requirement on contraceptives. Joining us on 710 KURV to help us examine the decision, attorney, former federal prosecutor, Douglas Burns. Welcome back to the show, Doug. So Hobby Lobby wins, but other companies that were part of this lawsuit also win. Any names that we recognize in there?
Actually, there were two main companies, Hobby Lobby and one other. I don't have the name right in front of me. But basically, Hobby Lobby prevailed on this particular case, but it's also been misreported to some extent. So let me clear it up. In other words, some media reports are saying that Hobby Lobby, objected to providing contraception. That's just flat out wrong. They were providing 16 out of 20 types of contraception, but objected to 4, which in their religious belief, at least the claim was, goes more into abortion, like the morning after pill.
The post-conception.
Post-conception stuff,
understood.
Right. So I think it's very unfortunate that there have been media reports saying, and even some prominent people, such as Hillary Clinton, saying that they did not want to provide contraception. That's just not true.
What does this mean for Hobby Lobby? Does that mean they can opt out of the Obamacare mandate and providing insurance to everyone, or is it? No,
I think what it means is that they raised a religious objection to that part of the law, which would have required them to provide these 4 types of contraception.
So, are there any plans out there that are providing coverage with sans the post-conception pills that kill the new?
Well, I think it's just a matter of fashioning the particular, coverage. In other words, they have the Religious Freedom Restoration Act. That was a law that was in play here. And basically, the standard's pretty wide open, which is the government taking an action that substantially burdens your freedom?
Yeah, but that's curious because in the market is supposed to provide everything by law at a certain standard now. So who's out there that's going to be providing this insurance coverage without this? Yeah.
You're making a great point, which is, when you have these lofty Supreme Court decisions, then you get into the pragmatics of how the heck are you going to implement it? And you're exactly right. But
who's going to calculate, let's deduct the cost of this. Yeah.
That's a good point. I mean, not too many people have said that. I mean, how is this really going to practically work? I think what it means basically is that Hobby Lobby turns around and says to their insurer, we are now not required to provide these 4, and they won't have to provide them. That's all. But again, you're right. Logistically, yes, it might be difficult to work.
Joining us on 710 KURV, attorney Douglas Burns.
Doug, Tim Sullivan here.
Hi,
so if this is a religious freedom issue, do we start going down a slippery slope here? What's to stop those companies with strongly held religious beliefs from, let's say, trying to ban blood transfusions because they don't like that, or let's even go towards collective bargaining, something of that sort?
Excellent question, because it highlights one of the more important things about yesterday's decision. And it was, I can't remember a decision in recent memory which was capable of being categorized so differently. In other words, those who support the majority opinion say Justice Alito was very careful to narrowly tailor it, but many espouse exactly what you just said, and I like the way you put it, which is, well, wait a minute, Ruth Bader Ginsburg in the dissent came out swinging.
A blistering
right in the first sentence. This is a broad, sweeping decision. I actually don't necessarily agree with her on this one. I have great respect for her. She's a brilliant legal scholar. But the fact of the matter is, I think Justice Alito made it pretty clear in the opinion that, the fact that this was, and law cases do tailor to their individual facts, that this was a small, closely held family business. And I think Alito was making it clear, Justice Alito, that this is not going to apply to huge corporations.
Okay, but they're calling it religious freedom, but this ruling is really based on really just one religion's doctrine.
Yeah, no. Look, Ruth Bader Ginsburg hung a footnote, and it's funny. I don't know if you read it because you portended it perfectly, and she was saying, well, wait a minute, what if this religion objects to the use of this particular animal? What if this religion objects, as you just said a moment ago, to a blood transfusion? But I think she's forecasting something that, first of all, there's 2 issues. Issue number 1 is, what would the Supreme Court do if a case came in with a big corporation? And that's a very valid question that you just asked. In my opinion, I'm very confident in predicting that they would not afford that type of, religious freedom point. The other question is, how are the lower courts going to interpret this? And the fact of the matter is that there's a lot of flexibility to turn around and say that the Supreme Court ruled that a small family-held close corporation, but this one isn't. So it's going to be very interesting. I think the proof in the pudding is going to be how the lower courts interpret this case.
What if there were 5 women on the Supreme Court? Would this have gone 5-4 the other way?
Oh, that's a great question. I mean, this thing, I think you have to hit the rewind button and go back to the Obamacare decision itself.
How would Sandra Day O'Connor have voted?
I think Sandra Day O'Connor would have been put in a really tough box.
Yeah.
And it's sad to say that because it's supposed to be legal analysis, but we know these are social hot-button issues. So I think if you had 5 women, it's very hard to say. But what I was saying is, given the original Obamacare decision, the Chief Justice could have gone the other way in this case.
That's assuming and putting a blanket interpretation on all women.
I don't want to,
outside the court. Outside the high court yesterday, nothing but women in defense of the unborn.
Bandwagon, right?
Absolutely.
But the reality is, 3 women, yes, they did vote in that way. Because Justice Sotomayor isn't necessarily always a rock solid vote.
That's true too.
Alito's opinion. How does it limit the spectrum of application here? What is it in the verbiage that in your mind he attempted to help?
Well, I think Justice Alito was emphasizing in the opinion. I read through it. I didn't, really study it that closely. And I'll look at it more. But, he was making it pretty clear by insinuation and even flat out that basically one of the most salient factual points here was that the people themselves, really was like a family business and that they held these beliefs. When you go into the big-time corporate boardrooms, I don't think Justice Alito, reading his mind, as I'm looking over at a picture of him with him and my late father, because he came to an event on Long Island, an legal organization that I was involved in. But the point is, I don't think he would ever rule that a big, huge corporation like, let's say Ford Motor or GM would be able to have that religious concept in their favor.
Doug, thank you for your time. Douglas Burns, former federal prosecutor, attorney, our guest on 710 KURV.